Dr. Justice Youngson, who is a former vice president of the Ghana Medical Association. Joining us on Zoom is Kwame Sapon-Asiedu, D&D Fellow on Public Health. Good morning to you, Justice Youngson, and good morning to you, Kwame Sapon-Asiedu.
Good morning, Winston.
Good morning.
Great. Now, let me start off with you, Justice Youngson, because I'm sure there's a conversation that we've had before, times that the GMA is backed on strike actions, and we ask the same question all the time. The Minister of Health has been indicating that, look, there are challenges. Why can't practitioners appreciate that there are challenges with the Ghanaian economy and thus must bear with government and at least serve till next year when their needs will be taken care of?
Okay, thank you very much, Winston. I think that we find ourselves in a very unique situation. Labor ultimately bears the brunt of all the hardships in the country. They are responsible for feeding their families. They are responsible to ensure that whatever happens at the workplace is smooth. They are the ones who are the productive forces for the state. And for that matter, whatever revenue we generate as a country is dependent on labor. However, when it comes to issues relating to their compensation, there's always this seeming lackadaisical approach. And it is not something that, excuse me to say, happened today or started today. It's been with us for decades. Different governments, whether blue, green, white or pink. So that particular issue, which has not been addressed properly over the years, is what ultimately leads to some of these agitations from time to time. If any government comes today or tomorrow and decides to slap taxes on us, we are compelled to pay, whether it's at a pump, whether it's through inflation, or whatever it is. Labor cannot say they will not feed their families or take care of themselves. So labor for a long time has been at this receiving end. And when the employer is called upon legally to do what they also ought to do for labor, then we begin to hear cries of, we don't have, we can't do that.
Justice Youngson, in reality, now the budget has been approved for this year. Compensation agreed already. How do you expect a government under an IMF program, tight budget, to find some 2 billion Ghana cedis to meet these demands?
Listen, let me just say this. I don't speak for the nurses or any professional body at this point. I'm speaking to you as a citizen, as somebody who has been in the labor space, somebody who understands the labor laws of Ghana because of my legal background, and somebody who also understands the dynamics at the health facilities. Now, see, compensation is something that cuts across the entirety of the state, from the first gentleman of the land to the very last person. Now, in this particular situation, if you listen to the nurses, what they are saying is that that agreement was signed between the employer and labor or the nurses as far back as 2024. And the understanding was that it was going to be part of the 2025 compensation. Now, when these agreements are signed, they are not signed in a vacuum. The negotiation processes leading to the signing of the agreement involves the workers, the Ministry of Finance, Ministry of Employment, the mother ministry of which particular labor group, so in this case, the Ministry of Health, as well as the legally mandated institution of state, the Fair Wages and Salaries Commission. And sometimes when these things are even signed, copies are lodged with the National Labour Commission. So it's a bit baffling when you hear that for some reason this particular document was not factored in the 2025 budget, unlike previous years where the budget may have been read somewhere November 2024, we had to do that interim one somewhere in December to cover January to March. And then the current administration, led by the current finance minister, had to then come in with the actual budget for the rest of the year. So from the June to March, it's a bit baffling when you hear that it was never factored, because the Ministry of Finance itself okayed all the details, at least based on what I have been privy to in previous negotiations, before the signing off happened. And they have copies. The compensation unit of the Ministry of Finance is always actively involved in this. The Ministry of Health itself technically is very much aware because they have their signatures appended to the document. And Fair Wages is also obliged to pass on all these things to the paymaster, i.e. the Ministry of Finance. So when you hear that for some reason it was not captured, well, it's baffling, but I cannot give explanations as to why. But listening to the nurses, it is clear that they are not happy about that situation. So for me, we've moved from the issue of the whole bit not being captured in the budget to a point where we need to find a resolution. See, this is a legally binding document. If you take our labor laws, it is clear. It is a right that they have earned because they have sat down, negotiated with the employer, and the employer has really agreed to certain terms. What most times we seem to forget is that it is not a one-way activity.
Okay.
Part of it part of that document puts some responsibilities on the nurses or the workers. Another part also puts some responsibilities on the employer. As we speak, before the strike, I'm sure the nurses were discharging their side of the bargain.
Okay.
It is just right that the employer also sits down with them to find the best approach to implementing this document, so that we can all move on.
Hold on 1 minute for me. Let me bring in Kwame Sapon-Siedu, Game, who's labor and ADR consultant and CEO of Game and Game Group. Now, Kwame, I mean, you've been monitoring the situation. Government has indicated that we can't pay that money this year. And you know the conditions in which we find ourselves. So please bear with us. Isn't that something that is understandable?
Thanks, Winston, and good morning to listeners and justice. Understandable. You see, when I'm confronted with things like this, I ask myself a basic question. What health system do we want versus what health system do we have? And are we sure that the situations we find ourselves in lean themselves towards the health system we want? Because look, when these negotiations were had initially in 2024, we were grappling with the issue of health worker migration. And if you remember at that time, Winston, we had a number of conversations on this same platform as the negotiations were going on, because we're talking about the professional migration and people were talking about poor remuneration as the a major factor, and other people were trying to say that the nurses were not patriotic enough. And I held the view that when it comes to bread and butter issues, patriotism is not a determinant. Because at the end of the day, when that nurse goes to pay the kids' school fees, when that nurse goes to pay for groceries, when they pay for electricity, when they pay for water, they wouldn't be asked for their patriotic card. They would have to pay or do without. So, as Dr. Yankson said, the negotiations have happened. How didn't it get into the budget? You see, and I struggle with that aspect. I don't know where the ball was dropped, but considering that there's been a change of government, was it that this was overlooked in the transition somewhere? And if so, how? If the current government got hold of the information and for some reason dropped the ball and didn't get it into the budget, or even if they had acknowledged that, well, we've taken over the reins of government, this is going to cost about 2 billion, but we cannot afford the whole 2 billion, even though the previous negotiation has said that we should factor it into this financial year. We were going to stagger it. And the conversations have started before the nurses had threatened strike action. Perhaps we wouldn't be having these conversations. And you see, it goes back to what Dr. Yankson was saying about a historic neglect of health human resources in Ghana. There is a historic neglect. And what I think this current compensation for nurses has tried to do is to correct the historic neglect, which then means that the global sum that has to be paid is a bit bigger than the government would probably normally have budgeted for. But that cannot be an excuse to say the nurses should do without. So at this point, I just think cool heads should prevail. Both parties would have to have a serious discussion, because there are two things here. We cannot compromise our health system. And I'll put some data out when I'm concluding so that people think about it properly. We cannot compromise our health system because people are dying and people would continue dying if the situation continues. We cannot break the back of the economy either, because we've seen what happens when we have ourselves in economic bother. Everyone would suffer, including the nurses. So cool heads has to prevail. The negotiations are finished. I don't think there need to be any renegotiation of the package because that's been concluded. But there should be a firm discussion about the implementation of the package. I think the bone of contention is that the government is saying they cannot start implementing this financial year and want to start from 2026. Perhaps that might be something that the government would have to, backpedal on and start the implementation from this year to ensure that it's working. And you see, I'll end this way. Yesterday, I put out some statistics about life expectancy. And it's a basic life expectancy on when a child is born in Ghana today, what's their probability of hitting 20 years, 40 years, 60 years, 70 years, and 80 years? If you compare, so I compared Ghana to the world, and I compared Ghana to the United Kingdom and Rwanda. A child born in Ghana today has 87% chance of hitting 20 years. A child born in the UK has 99% chance. Rwanda has 88%. When it gets to 40 years, a child born in Ghana today has a 70% chance of growing to 40. Rwanda is 75.
Hello, Kwame. Hello? Hello, Kwame. Oh, I think we may have lost Kwame. Let me just try. Let's just try and get, back to Kwame. But we've been joined on the phone. Austin Gami, who is a labor and ADR consultant and CEO of Gami and Gami Group. Mr. Gami, good morning, and thank you very much for joining us. Great. So I know you've been in negotiations. You've handled many of these issues. Let's look at the, government and nurses impasse, for instance. Let's look at the government's posturing. Now, the nurses say, well, there's an agreement, implemented. Government says, I cannot implement it. I can only do so next year. Is the government's posturing the right posturing, considering that this is an agreement that was reached last year and expected to be implemented?
Well, thank you so much. I think I've heard many people talking about this issue, and it concerns me a lot and gives me pause of things. Yesterday, I was teaching at Legon, those doing masters in industrial relations, and this was part of the subject matter. Not necessarily the nurses issue, but talking about labor collective agreement, its history, and the framework and the effect on the economy as the case may be. So, to be very honest with you, I've heard many people saying that agreement has been reached. It is not to be negotiated again. It's for implementation. It's not correct. In industrial relations, when you are negotiating, when you have concluded the negotiation, when you have to implement the negotiation, it's all subject to review.
Okay.
Now, the parties that sat to negotiate the condition of service, if one party has a genuine concern, it has to be raised. But you can't raise it on your own terms. That is that you cannot do it unilaterally.
Okay.
The social partner with whom you negotiated with, you have to invite them. You sit and explain why you are having the concern you are having. And under Section 97 of the Labour Act, you have to share that relevant information with one another. And when you finish that, and there is no conclusion between the two of you, what it means is that you have not been able to reach agreement on the implementation process. Agreement concluded is for implementation. Implementation stage is also an action to be taken. And so if you have a problem, you discuss it. If one party do not agree, you go to the National Labour Commission for assistance, or you go to a mediator for assistance. This is not something you have to go for arbitration per se. The arbitration will produce a winner and a loser.
Okay.
And one person will not be happy to create the furore like the type we are seeing now. So wisely, you get somebody with the background of that experience to assist the two parties to resolve the differences. I think the Labour Commission has the capacity. We have several other people who can assist us to do it.
Okay.
But to say that it is not to be negotiated again, it's not entirely correct.
All right.
And two, if you are to even implement the agreement, and I'm unable as an employer to implement it according to what we have done, that discussion is negotiation. So people should not be fixated with the word negotiation as if it's something that is strange. It's not strange.
Okay. Now, Mr. Kame, I mean, you talked about the fact that while that can be renegotiated, or you also make the point that it cannot be unilateral. So let's look at the positions here. Now, government says we cannot pay this year because it will throw our budget out of gear. It's going to cost $2 billion, and that's something we cannot do. Under the circumstance, would it have been, say, appropriate for government to probably have made an offer and say we can pay this amount while we pay the remainder this year, or the wholesale we cannot pay is the right way to go in a negotiation of this nature?
That is the reason why the labor law made provision for this kind of conversation. And you cannot be on strike and having that conversation. The law forbids, whether in Ghana, whether in Japan, whether in America, whether in Azerbaijan, the law forbids for anybody to be on strike at the same time having a discussion. It's not a war zone. It's a labor relations matter. So you don't have to even put on red band according to the law. You cannot be threatening somebody, hold somebody hand at the back, and you say, come on, let's stop on my terms. This is like you are dictating to the person. It's a unilateral approach, which the employer is being accused of, that the union is also visiting on the employer. So both parties have to sit down, have a civilized conversation. If it's going to be a payment plan, you bring your offer. You also bring your offer, not even position. My position is this. Our position is this. It's positional negotiation. And it's not part of our labor law at all. It's lack of knowledge that's creating the problem. Okay. So I think that I would plead with both parties. They will have to, the unionized people within the nursing fraternity, they know that they have to go back to work. And let the employer also get away from the poster everybody else is talking about. Let them go to the table, go and sit down, and have a conversation about any plan that is worth implementing. You can't force the employer to pay you when they cannot afford to pay. You cannot do that. You can't force a horse to a riverside to go and drink water. He will put his mouth inside, he will not drink. There are several ways that the employer can ask them to be paid, but it may not be lasting. So, and the nurses know that. They know that. So, patience will be required, and I think that this is a matter that can be resolved. Let me use the word easily. But the way they are going about it is what is creating the problem.
When you say it can be resolved easily, okay, now you've made the point that you cannot be. I mean, the laws make the provision. You cannot be on strike and be negotiating. So they go back, but you also make the point that you cannot force the employer to pay you. At the same time, you make the point also that you cannot unilaterally say, "I cannot do this." So let's look for a negotiation approach. You've talked also about a payment, and that brings me to the confusion. When they go back, for instance, now that there's been the nurses, there's a substituted service, they've been served. I'm sure they're going to be calling off the strike. Yesterday, I heard them on Newsnight saying they don't have a choice but to call off the strike. Now, if they go back to the negotiation table, that plan that you talk about, what form should it take?
It can take several forms.
Okay.
For instance, the teaching hospitals, they have a system in place that can pay the people who are there and relieve the direct exchequer from being the one paying. I'm just giving you one example.
Okay.
Panebo Teaching Hospital can pay. Kumasi Teaching Hospital can pay. Maybe Tamale Teaching Hospital can pay. Maybe X can pay. Maybe a certain child institution can pay. Look, so it is not for them to be on strike and be somewhere and not being at the negotiation table. If I were to be sitting between them, I can guarantee you not more than 90 minutes, this matter will be over.
So if I get
more than 90 minutes, this matter will be over.
If I get you correctly, you're suggesting that one of the ways could be the usage of their IGF, some of the facilities, their IGF, to pay some of these allowances, while government finds ways to pay the others, right?
It's part of it, and it's subject to discussion. And you have to involve the teaching hospitals to enable them look at their budget and do the variations. It's not a one-day matter. That's why they must be patient and have a discussion. If you are holding the other party hand at the back and say, "Come and let's negotiate," it won't work. Meanwhile, people are dying, so desperation set in, and the employer says that I'm going to look for people to be resolving the matter temporarily whilst you are on strike. You may not understand.
Please hold on for us, Mr. Austin Gami. Let me just get Dr. Justice Yankson, former Vice President of the Ghana Medical Association's view on this. Dr. Austin Gami make the point that there are different ways of going about this, and he's proffered some of the ways which he believes can help solve this. Way to go?
Winston, let me say good morning to Mr. Gami, my dear friend. But I think that I have a challenge with his interpretation and use of negotiation.
Okay.
Look, the legal position is very clear. We negotiate the conditions of service or collective bargaining agreement. And then at the point, we come to a conclusion and sign the document. Once that document has been signed, it also includes an implementation date or a start date for implementation. All of these would have been agreed on by the two parties, the employer as well as the workers. Now, that document that has been concluded cannot be the subject matter of a renegotiation at this point. If you want to renegotiate that document, any of the two parties who has a concern will have to write formally to the other for the two parties to discuss. First, the other party will have to agree. If they don't agree, you cannot proceed. If they agree, then they sit down with you and see which aspect of that document that you think has to be relooked. That is about the details of that document called the CBA or the condition of service document. The other leg, which is the implementation, we don't talk about negotiations. You basically discuss an implementation plan or strategy. In fact, in some negotiations, these implementation activities would have even been discussed before the signing of the document that tells you the start date. So here, I think the clarity that ought to be brought is that we are not at the point of renegotiation of that document. No, we are talking about implementation. So the best approach, as Mr. GRNMA was trying to say, is for the two parties to discuss and agree on an implementation plan that is different from the details of the document that people are talking about renegotiation. So I think we need to bring that clarity to the fore. Now, Mr. GRNMA mentioned or used the word, you can take the horse to the riverside, but you can't force it to drink. Same applies to both sides of this conflict. If you think that you can use legalities to send the workers back to work, at the workplace, can you force them to drink? And look, the healthcare area is a specialized area. Excuse me to say, it is not like all other activities. If you have a disgruntled or demotivated group of employees, you are not going to get ultimate results. And the impact will be on all of us. We need to tread cautiously. Look, yesterday, it is good when I heard from the first vice president of the nurses saying that as law-abiding citizens, they will abide by what the court says. And that even at that point, their council will have to meet and come up with a way forward. But he also went on to say, is that the solution? Because this interim or interlocutory injunction is valid for 10 days. At that point, they reserve the right to go back to their current action. If anybody wants to do anything, you have to go on notice. So clearly there are issues. As we speak, we're talking about 2 billion. Has anybody sat down to calculate the amount of money that all the health facilities nationwide are losing or have lost up till today and may continue to lose? I tell you what, that economic angle alone might probably even be more than the 2 billion. Two, when we take the economic aspect aside, the general impact on all of us and our abilities to give our best at our various workplaces, i.e., if somebody is sick and cannot recover early or quickly because care hasn't been optimized, that person might also not be able to go back to contribute to the bigger economy. And that is also another implication that will set the bigger economy. So I think that where we are now, government or the employer, I don't want to say government, it's between the employer and the workers, will have to backpedal, that's what I said, and have an implementation plan that takes into consideration the sentiments of the nurses as we speak, such that we can have a plan which can be implemented either in full or in part, in a staggered manner or whichever approach, so that it becomes a win-win situation for both ends. That is the only way out.
Okay.
If you think that you can use legalities to bully them, unfortunately, it is no. And it's funny, or it is quite interesting. Anytime experts or commentators talk about the illegalities of what the workers are doing, they refuse to also talk about the illegalities of the employer. Look, if you take the Labor Act, this particular issue, we shouldn't be where we are because the Labor Act is so clear. No matter how you stretch it, you cannot go beyond 3 weeks when it comes to resolution of issues concerning essential services. If you really deem the work of nurses as part of the essential services, the state institutions from Labour Commission to the Fair Wages to whoever, should have borne this in mind as well, and also respected the provisions within those particular clauses of the Act. We just at a point where I think all we need to do is that both sides will have to backtrack, extend an olive branch as an employer to the workers, sit down and have some implementation plan in place. It might not be a complete or total implementation of all the clauses effective today, but there can always be a way of doing it, so that even if some arrears may have to be paid, I'm sure the workers will agree. If, for example, the implementation date, assuming it says January, has to be moved to say even July in terms of the real effective date, I'm sure some of these workers are ready to listen to some of these things. But to say that we cannot accommodate your request in any way, when it has been known to you for months, then I think that there's a bit of bad faith.
So if I get you clearly, your point is that, yes, at all costs, they must sit down. But in sitting down, government must at least indicate some form of payment it intends to make this year, and then can talk about spreading the remainder somewhere next year, right?
I mean, it is one of the approaches, yes. All I'm trying to say is that between the two parties, they can agree on something. And I know that workers are reasonable. It has happened to my group before. So I know that workers are reasonable. Once we have a certain approach, that does not totally neglect the implementation of that document, then we have a solution at hand.
Okay. I still have Austin Game, who's Labor and ADR consultant and CEO of Game and Game Group, and Kwame Sapong Asiedu.
Yeah.
Yes, Mr. Game, do you want to make a point briefly before I go to Kwame and come back to you?
Listen, let me be very clear here.
Okay, please go ahead.
First of all, greetings to my friend, Dr. Jensen. We have been working on some of these things for a very long time. Let me just say this. He has said virtually the same thing I've said in another form. The only point is that in labor relations, there is no legalistic approach. That's why it is called industrial relations. It's not even a matter to be even arbitrated on. It's either you negotiate or you mediate, so that you have people satisfied and there is a mutual respect for everybody. And it will not be done, I repeat, unilaterally by either party. That is the point of view. And so I appreciate that, and I think that he has said what I've said in another form. So I go with what he has said. Let everybody understand that you cannot be on strike and be negotiating. And Dr. Yancy knows that very well. Whoever is a teacher of this knows that nobody should ever be on strike and be negotiating. Our labor law is very, very clear on it. And so everybody must understand that, whether in private sector or government sector, is the same. And I want to meet a notable union that is highly respected in this country. They have negotiated. I was present at the meeting as a facilitator for both parties. They negotiated, concluded. It was partially announced to the workers already. Then the employer did some few things and realized that they have made mistakes. They called the parties back to the table. I was present. 1.5 hours discussion. We resolved the matter. We varied the figures. Whatever is negotiated and agreed upon can be varied by the parties that put the thing together. That's the point. That is the way to go. You cannot take positional on a matter that because you have done it and it's done and dusted forever, it remains the same. Are you going to generate the money to pay? Somebody must pay.
Sure.
Somebody must account for it. So it's about being patient and listening to the other side also, devoid of emotions. This is the point.
Okay, let me bring Kwame Sapon-Asidu. Please stay with us. Let me bring Kwame Sapon-Asidu. So, Kwame, sorry, we lost you at some point. You're making a point. You're actually indicating, you know,
Yes,
yes.
I was saying that we have a health system, and whilst this is going on, that health system is suffering. And my point was that if you take a child born today in Ghana, that child has only 20% chance of growing to the age 70. Whereas in the UK, that child has a 90% chance of growing to the age of 70. I hope you get me.
Yes,
So
I do.
there are fundamental problems with the health system that need fixing. Part of it is remuneration, because I've always said this, that health, apart from being a science, is a vocation as well. And therefore, you hone your skills as you go along. And the longer you are a practitioner, the better your skills become fine. Unfortunately, when you lose the best practitioners, either through migration, either through strike action, and you bring in other people, because it's a vocation and the skills drop, people die. And that's my only concern. While we are going at this, we are going to lose lives. So, and that is why I am saying that our trajectory in aging is bad anyway. Are we going to be sitting here having these conversations, the nurses standing on one side and holding their ground, the government standing on another side holding their ground, while people die or their prognosis gets worse?
And you say, Kwame, that when it comes to conditions of service, when it comes to buying things, you don't use your patriotic card. So, in effect, we must pay them.
I mean, that's a fact of life. I'm wondering, have you ever used your patriotic card to buy anything at the filling station? You don't use your patriotic card to buy anything. Nowhere in the world do you use your patriotic card to buy anything. You buy things based on your earnings or your investments. And so much as I can understand the position of government that the fiscal space is constrained, I can understand why the nurses would also want to draw their pound of flesh on the basis that whether you bleed or not, that flesh is theirs. But like we saw in in the Merchant of Venice, you always have to remember that you bargain to cut a pound of flesh and for no blood to drop. So in cutting that flesh, the other party can say, well, yes, cut your flesh and let no blood drop. But would that solve the problem? That wouldn't solve the problem. And that is why I agree with Mr. Austin Gammon that cool heads would have to prevail at this point. I am of the view that whatever has been negotiated as a package for them as their new condition of service is done. I hold the view what can be varied, and I've heard Justice Yankton say it, I've heard Mr. Austin Gammon say, is the implementation plan and how the payments will be done. And I think that is where the focus should be at this point in time. If, in my personal opinion, to try and renegotiate their conditions of service would open an entirely different can of worms, and it wouldn't be pleasant for any of us.
Finally, on this, Mr. Austin Gammon, before I get to Justice Yankson, you've talked about one of the ways that government can deal with this. Now that the nurses say they're going to go back to work, what other ways should government be looking at dealing with this immediately?
Well, to be very honest with you, I think that a certain reorientation on the part of everybody in this country, including them, matters now. People think they know about the labor law, but they don't know. We have not even implemented 1/3 of the Labor Act yet. It's so clear, very, very, very unambiguous that if it's well implemented, we don't have a problem. We anticipated that we might become like Singapore tomorrow. So the labor law was written with a view of having to ensure that we have a continuity of employment, we have a continuity of systems, Example, 24-hour economy has been catered for in the shift system that is programmed in the labor law already. So everything, if the government want to bring about a new proper performance management system, we have catered for it in the law already. So people must be paid very well, but based on productivity. That I want to suggest to government to put together a team now, and the word is now, emphasis now, that we must have a system in place that should pay workers very, very well, but based on productivity. And I can show you in the law, is there black and white in diverse ways. So we are abusing, wasting our energy. We have a mushroom of allowances that is now a subject matter for strikes, and we cannot pay. Mushroom of allowances, and people don't retire on allowances; they retire on their pay. So workers who are being led by their leaders should understand that it's about time they should ask that they are prepared for the employer to give them their work to do, their targets to perform, and they must be paid based upon productivity so that they can earn good pay and have good pension. Most of the people who are on strike now, they will go on pension tomorrow next, and they will not be paid allowances. So I think that people should realize that and be open to this kind of discussion. In the meantime, I congratulate them if they are going back to work. They should go. I'm prepared to assist them to resolve the rest of the matter if they so wish.
Great. Justice Youngson, finally from you.
Well, I think that at this point, the two parties, the employer, should actually calm down, reach out to the employees, and make sure that ASAP a certain implementation plan is agreed on that ultimately does not make the worker worse off, but can be in the form of a staggering approach or a partial implementation for now, and then a ramped up implementation at some point in time. Usually these documents are for a specified period, 2 or 3 years. I'm not too sure whether in this case it is 2 or 3. But within that period, the economic rights of the workers should be guaranteed as far as the discussions leading to a proper implementation plan, which would have been agreed on by both parties, that at least has some level of flexibility, but ultimately compensates the workers for them to also give up their best, is what we need at this point.
Thank you very much, Dr. Justice Youngson, former Vice President of the Ghana Medical Association. Thank you, Austin Game, Labor and ADR Consultant and CEO of Game & Game Group, and to you, Kwame Sapon-Siedu, D&D Fellow on Public Health. Thank you very much, all of you, for joining us here on the Super Morning Show. So the conclusion is that, look, nurses going back, they've indicated they don't have a choice. Council, they would have to go back. But as they even go back, you had the experts make the point that government must engage, and government must, they must not go into this with a unilateral position. We don't have money. Look at ways of raising money and settling it.